We have another Q&A session here at Karen, Paul and Associates, as always, Thursday, 1 o'clock. Again, this week we are bringing a fantastic guest. We have Anika from Carson Law, who is a paralegal and deals a lot with tenant and landlord issues. Thank you so much for joining our call today. If you could take a couple minutes, talk a little bit about yourself, your role, and what you're all about.
Okay, so I'm Anika. I am with Carson Law as a full-time paralegal. I started at the firm back in 2020 January. Prior to that, I worked with the Department of Justice as a paralegal. The commuting took a toll on me over time, so I thought it was time to switch over to somewhere close to where I lived. So that's when I reached out to Carson Law and have been there since. I deal mostly with landlord and tenant law and small claim court matters. So recently with COVID, I've been getting a lot more landlord and tenant board matters compared to small claims. So it's just been a busy time.
That's fantastic, and exactly why we wanted to have you on today. Someone as knowledgeable about tenant-landlord issues. As realtors, obviously, we do run into that quite a lot, whether we're representing our landlords or representing our tenants. You know, there's always seems to be at least some conflict. So you touched on a really good point there, Anika, and kind of goes to speak of what's kind of going on in the marketplace with tensions between landlords and tenants. So you said since COVID's happened, you've increased a lot of your time going towards these sort of issues. Do you have some insight onto why, what's kind of causing this? Obviously, I'm sure there's some, small issues here and there, but maybe overall trends that you can discuss.
Even before COVID, the landlord and tenant issues was always a thing that we saw on a weekly basis, because tenants are quite protected in Ontario. So it's just, it takes a toll on the process and makes the process longer because you have to go through all these hoops to get to the end of, to resolve an issue. But since COVID, because of backlog, like it all started with the legal field not being entirely efficient with technology and using Zoom and calls and all that to conduct hearings when COVID started out. So, a lot of hearings were canceled. People weren't able to file applications on time. Things just started. It was more like a snowball effect at that point. So at this point, all the delays are mostly because the tribunals are basically catching up, and they're doing a very good job so far. Like last year, we were looking at about 18 to 24 months to get a hearing. Now we're at about 4 to 6 months. So it's not, we're finally starting to catch up. And, just in terms of seeing more applications for evictions in terms of like landlord's perspective, it's mostly because with a lot of people losing their jobs, a lot of tenants couldn't, get to the point where they could make all the rent payments, and it kept piling up. A lot of people went on payment plans, but over time, it just didn't work out for a lot of people. And as much as we do sympathize with a lot of tenants, landlords would also have to pay, their mortgage, right? So it just it always ended up going to the board and the whole eviction process. So it's just...
It's a lot going on, and there's two sides of it, and I can only imagine, a lot of people do find themselves in situations like that, and what is the right answer, right? Mm-hmm. Extremely difficult. So I just wanted to ask, before you had mentioned two different timelines. So you said last year 18 to 24 months for a hearing. Now you said, I believe, 4 to 8 or 6 to 8
months.
4 to 6, fantastic. And let's say pre-COVID, say 3 years ago, what were you kind of looking at in terms of
about 2 to 3 months.
Okay, so we're pretty close to what it was, before this lovely virus decided to change the whole world.
Yeah.
Absolutely. Okay. Oh, and I just see Karen just jumped on. Hey, Karen, how are you?
I'm good. I'm sorry. I'm just driving back from an inspection.
Excellent. Well, thanks for jumping on. Anika, just to jump back into our sort of the eviction process and, why cases actually go and reach the board. So let's just say, let's kind of play out a scenario here, and you can kind of walk me through it. Let's say there's a tenant, obviously there's a lease agreement in place, and whether for whatever reason non-payment of rent has taken place. What is the right and correct process for a landlord to start dealing with, that type of situation?
Right. Well, the first way I would go about it is usually you want to have a conversation with the tenant, right? Just to make sure if they're dealing with a situation that is preventing them from paying rent. After you've had that conversation, if it seems like they're going to withhold rent or they're not going to pay it at all, or, it's just they haven't paid and it has turned into a pattern, the right way to start is, you go ahead and you serve an N4. It's a notice to end a tenancy early for non-payment of rent. So the notice provides 14-day. It's a 14-day notice period that gives your tenant that time to either pay up the rent arrears or move out of the unit. And for example, so there's two situations. 14-day notice period is required for tenants that are paying month-to-month basis or on a yearly basis. And 7-day notice period would be for tenants that are paying by the day or the week. So the most common that we see is the 14-day period. It's because, it's either a yearly lease or, the lease has ended and then the tenant's paying on a month-to-month basis. So once you serve an N4, if your tenant pays up within that 14 days, the notice becomes void, right? So because the notice is basically like a paper trail to start an application if necessary. So you provide the notice, you have 14 days, your tenant pays up, he voids or she voids the notice and you're good to go. You have your tenant, they're paying again. For whatever reason, if they're not paying the rent within those 14 days, on that 15th day, you can actually go ahead and file an L1 with the board. So that would have to be filed with the Landlord and Tenant Board. That would be an application to evict a tenant for non-payment of rent and to collect the rent. So it will be for both. Once you file that application, it's pretty similar, like in terms of all the other applications that you file with the board. It's just the forms are different, but you file the form, you state your reasons as to why and how long they haven't paid for, what the rent amount is that hasn't been paid so far. Once you file it, it's just a matter of waiting for a hearing at that point. Once you get the hearing, the adjudicator would usually give you an order for eviction or hear the other sides of the story. And if your tenant does have a good reason as to why they're not paying rent, they would either get put on a payment plan to give them a second chance. And we have been seeing that a lot recently because of COVID. So tenants tend to go back and they do execute the payment plan quite easily, but it turns out that after a couple of months, it's back to square one where they can't pay rent again, and then you go back to the board. So you will see that sometimes boards are giving that second chances to tenants, but in the end of the day, if it keeps happening, you just file that application again with the board, and most of the times you will get an eviction order.
Okay. And so just working through timeline. So it's a 2-week after non-payment. You follow the proper protocol. You bring in the N4 and then you bring it over. Well, the N4 goes to the tenant. You bring the next one over to the tribunal and wait for your hearing. So good. That's great information. We deal with a lot of landlords, and I know the process in which everything is executed is extremely, extremely important. So you had mentioned a couple different forms, and the N4 was a big one. Now, we hear a lot of an N11 and an N12 coming into play. Some of the harder-handed forms, I would say. Can you talk to me about, explain each one of those and the situations in which they'd apply, and again, just to why it is so important to handle the forms and the processes around serving these correctly?
Okay, so N11 is the form that is used to end a tenancy at the end of a lease termination period. It's usually used when, both parties are agreeing to end the lease mutually. Usually served by a landlord. Say you have a 2-year lease with a tenant and you both have agreed that after that 2 years, you're not going to go on a month-to-month basis. They're agreeing to move on, you're agreeing to move on. So you would just serve an N11. And there's basically no underlying reasons as to why the tenancy is ending other than the fact that you have both chosen to move on, right? So that's just a basic form to end a tenancy on time for no good reason sometimes. You can ask your tenant to sign the form, and once they sign it, it's like a contract, right? The form acts as a contract because you're not coercing them into signing it. They agree to it. There's no compensation for it. It's just a mutual agreement. So you both sign it. And we do hear from time to time that, a tenant has signed an N11 but hasn't moved out by the termination date. So a lot of landlords, they sort of get confused in the situation that they think they have to apply to the board and wait for a hearing and get an eviction order. With N11, it's quite not the case. So say you have a signed N11 with a tenant and they do not move out by, whatever the termination date is, you still do have to apply to the board, but it's a very short process. You apply to the board with an L3 application. It's an application to end a tenancy and evict a tenant. Again, for no reason, right? Just an application to end the tenancy. There's no hearing required at all. So once you file the application, the wait time right now is about 2 to 3 weeks, as far as I've seen. In the past couple of months, the judge or the adjudicator, they just go ahead and issue an order right away. So there will be no hearing held at all, just because, your tenant has signed it and it's more like a contract at that point. They would have to move out. And if they try, because of the backlog, it's hard, but at least before COVID, they used to try and have the eviction order or the eviction date to be on the same day as the termination date to make it easier on landlords. But with all the backlogs happening, we're still looking at about 2 to 3 weeks after the eviction date, but it's a pretty straightforward, process. You sign the N11, they don't move out, you apply with an L3, you get an eviction order, you take it to the sheriff, because again, I'm not sure if everybody's aware, but you can't have your tenant, you can't drag them out of the unit, or you can't do it yourself. You have to have a sheriff with you. So you take that eviction order with you, go to the sheriff, and they will assist you in getting that tenant out of the unit. So that's entirely N11. Again, no reason at all. You're just not continuing the tenancy. With an N12, it's a little bit different, because N12 is the notice that you provide to your tenant when you, as the landlord or a new purchaser or a family member of the landlord or a new purchaser, is moving into the rental unit. And when I say family members, it cannot be like a second, some
immediate family.
Yeah, or a caregiver, or it could be your brother, but it cannot be like a friend of a friend moving in, because a lot of people do tend to do that just to, qualify to get the tenant out, but that's considered in bad faith. So I would say always stick to, actual family members, or at least with some sort of family ties. With that being said, the process is a little bit more lengthier than an N11, because you have to sort of show that you do require the unit for yourself and not to rent it out for a higher, rent to a new tenant. So once you decide, or once you know that you require the unit, you're basically going to use the form, and you're going to provide the termination date, which is about 60 days. And the termination date has to be always at the end of the month. So for example, I've realized a lot of people make the mistake because it's just not clearly written anywhere.
First.
So yeah, like for example, if you want your tenant to get 60 days notice and you want them to move out by the end of March, you have to make sure you provide the notice by this month and not February 1st and then expect them to move out on March 31st, right? Like even a day could void a form. The board's just very, sticky when it comes to that kind of stuff. So 60 days notice and 1 month's rent compensation. So if they're moving out because you're moving in or your family's moving in, you have to make sure that you give them equals to like whatever rent they're paying you. You have to pay them back. Or what we've seen that, a lot of landlords kind of have a discussion with their tenant as to whether they want the money, like whether they want to keep paying the rent and then they want the money in cash or, however, once they move out, or whether, they want a free month, right? So it really depends on how or what the tenant chooses. A lot of landlords do reach out saying, can I do a free month instead of giving them money? So as long as your tenant agrees with it and it's written somewhere, then you're good to go.
I want to just jump in and ask you a quick question there, Anika. So N12. So let's say you are you're an owner of a rental property, and you're going to sell it. Okay. And you're not sure it's not going to go to a family member. You're going to put it on the open market and, whoever buys it, buys it. Let's say there's a tenant in there right away and you serve an N12 and let's say the closing date and everything lines up for 60, 90 days, whatever it is. What would be the process if during your showing time, like when you're trying to show the property and let's say even on closing, that tenant does not want to cooperate? What would be a reasonable and what would be the recommendation on how to deal with that?
So for that, you still have to go to the board. Yeah, there's no way of forcing into the unit or just making them, letting you into the unit for showings, because it does tend to get, awkward and just not, some tenants just, I've heard violent stories too, so that's just not a good idea. But if your tenant's just not being reasonable, I would say go to the board. They're very good at advising us depending on the situation. Like I can't really give out legal advice because I don't know what, most situations are, but
and we won't hold you to it.
The best way to go would be, to go to the board, to have a chat with, whoever's assisting you there. And depending on the situation, sometimes they do provide an order that you can provide to your tenant that shows it's, it's a legal order that they have to let you in. And that's, as a landlord, it's your right. Right? As long as you've given them an N12 and given them the 24-hour notice to get into the unit, as long as you have done things as per the rules and the board sees it, it shouldn't be too hard.
Okay, great information, because I know we've run into some situations over the last, little while, and that's always good to know. So you've kind of already touched on it on a little bit. I just want to move to the next question. And it's talking about some of the main reasons for the long delays. So you've kind of already hit on that one. So let me kind of change that question and say, what are some of the main issues that you as a paralegal and your firm would be dealing with? You mentioned, there's been some income problems with COVID, and I'm sure that's a lot, a big portion of it. But any other, situations that you do see more often than others?
It's, to be very honest with you, it's mostly people dealing with moving into the unit, or N13. It's when you're trying to evict the tenant because you want to convert or renovate your unit, and the renovations are so major that it would be a hindrance for the tenants to stay. So that's what we've been getting a lot recently, and the most common cases I have gotten in the past couple of months is usually because the tenant doesn't want to pay rent. Even when they have money, sometimes it's just, the relationship falls apart. The tenant doesn't want to pay to make a point. The landlord gets stressed. So it just spirals on from there. So what we've been getting a lot is cash for keys deals, because when it comes to money, tenants seem to like that option a lot more than going through the board. So a lot of our, investors, they do take that route. When the tenant doesn't want to move out, they don't want to pay the rent. But when offered cash, it does seem attractive, and a lot of tenants have been agreeing to it.
So just let me jump in there. Awesome point, and I'm glad you brought that up. And just for everyone who might not know exactly what cash for keys are, do you mind just explaining exactly what that means in a situation where it could apply?
Yeah, it's pretty simple, and it's exactly how it sounds. Say, for example, your tenant's not paying rent and you have six months in arrears, so you are, in long term, you are ending up losing money. But it's hard to evict a tenant and go through the whole landlord and tenant process, because it's, again, to file an application, it takes money. Everything takes money, right? So sometimes tenants agree to move out of your unit in return of compensation, however much that may be, right? Sometimes it's 3 months, sometimes it's a whole year worth of rent. So it depends on how big of an investor are you, it depends on how much money you're willing to give away to your tenant to move out. So it has to be a win-win situation on both ends, right? Like, the landlord shouldn't have to end up losing money to get their tenant out. So it's just a situation where the tenant wins and the landlord gets what they want. So both parties walk away happy. To add to that, if you are doing cash for keys, the most common form to use is N11. So sign an N11. I do always suggest that it's easier to have like a written affidavit or a contract on the side to mention cash for keys, just to make sure that, that landlords can show that the tenants weren't coerced into it. Both parties sign the contract, you sign the end form, and you walk away with, somewhat winning.
Keys and cash. So both people are happy. Okay. Well, what a great great insight. And I know from my personal experience working with the investors that I do, and that is a very, very common avenue that people are exploring. And from my experience, I'd have to agree with you, Anika, that a lot of people are going that way, and usually is the better option from what I've seen. Okay, well, that's fantastic. On to the next one. So I wanted to talk to you about rent controls. There are rent controls in Ontario. They only apply to certain buildings and certain ages of buildings. Mm-hmm. And just wanted to put that out there because we do receive a lot of questions from tenants, from people that we know, from our landlord clients as well, just for clarity regarding rent controls. So just wanted to pass that on over to you, and if you could just dive into that topic a little bit.
Right. Rent control is basically, it's there to prevent landlords from gouging their tenants, right? Because with the market being the way it is, it's quite common that there's more demand than supply. So it's just to make sure that you as a landlord, or whoever as a landlord, is not charging their tenants an unfair amount to rent a unit. So it's just for rent regulation, but not all buildings are covered. So any buildings or any extensions of buildings or new basements that were done before November 15, 2018, you do have to follow the rent regulation. So rent control sort of covers everything and anything that was done before November 15, 2018. Now, any new basements or new units or even extensions to older buildings that was done after the fact, it's not covered. So as long as your tenant agrees to pay you whatever you're asking for and they're okay with it, you can, as long as your building or your basement or your house was built after November 15, 2018. So as long as you have that date in mind, and every time you're dealing with a house or if you're buying and selling, as long as you know when it was built and just have the proper information on hand, you should just be able to go off of that. And rent increase, like the percentage of how much you can increase your rent, sort of changes every year. So if you do go to the Landlord and Tenant Board website, They have a rent increase page dedicated with all the brochures. So every year they release a document and there's a new percentage as to how much you can increase it. As long as you follow that, you should be good. And if you're dealing with a unit that has no rent control, right, it's just a matter of having a conversation with your tenant. So if they want to pay you, like if you want $500 extra, above market value, and if they agree with it, then you're good to go. Like you wouldn't be in trouble for that at all.
And again, it's just knowing all your information,
Yeah.
making sure you're doing it the right way. Now, I have a question for you, and I personally, I'm not sure, but do you know how they come to the figure on where they get the rent control, like where they get the increases from? I would imagine it's it's a total, they probably look at everything, GDP, inflation rates, everything like that. But out of curiosity, do you know how they come to determine what annual increase is permitted?
I would want to answer that, but I'm not entirely sure. But
yeah, okay.
I will get back to you at a later time on that.
Okay, not a problem. It just came to me right there. So I wanted to open it up, Q𝘂𝗲𝗀 and Karen, if you guys wanted to jump in, ask any questions, I think would be a great time. Karen, you just jumped off mute.
I just have one question, and that would be the rent control. Is that applicable to commercial and residential? Is it all under the Landlord and Tenant Board, the commercial aspect also?
It is, as far as I know, at least when I checked last night, it only applied to residential complexes.
So it only applies to residential?
At the, in RTA,
yes.
which is the Residential Tenancies Act, that's the only place I've seen it so far. I don't necessarily deal with commercial units as much, so I would have to look into that. But the rent control with the date and stuff, it's usually like the one that I was talking about has to do with residential units only.
Yeah. So in residential, and I know that there are a lot of people who rented 4 or 5 years ago, and they're paying a lot less rent than what the rental rates are now. The landlords, some of them are very annoyed by that because they can't raise their rents to the going rate. And so what is the solution to that? Because I know landlords are getting pretty feisty about it sometimes. What do you run into that and a tenant coming to you and saying, hey, my landlord wanted to raise my rent by another $1,000 because of the going rates being at that? How do you feel about that?
Well, there's a process to it. Even though we do have, the percentage for every year, if you think that inflation and everything, or it just the rent should be high and they're still paying like way lower than market value, I know that there's an application that you can file with the board where, a judge listens and looks at your costs and everything that has gone up over the past, however many years. And if they think that it is fair to increase above the guideline, they will give you an order for that. Like, you do have the option to go to the board and sit down and explain your situation. And it might not be entirely at market value, but they do allow it sometimes. But unfortunately, that's just not something that's always successful because, if you let one person do it, every landlord's going to try and do it. So they try and not approve everybody who's applying unless you have a very good reason as to why. Like if you're losing money in the long run, they would allow you to increase a couple of, just a little bit more, but it's never, to exactly what you would want. And it is frustrating. And, I agree with you, but it's what the process is. And I wish I had a better answer, but
But
that would be a question that I too have for the Landlord and Tenant Board and, all the rules in Ontario. So, yeah.
Well, Q𝘂𝗲𝗀, is there anything you wanted to add? Are you?
No, I think you hit the nail on the head with the tenants not allowing people in and all that stuff, because I know in the last, almost 4 years that I've worked here, I think we've had about a good 3 or 4 tenants that we've had to deal with that were not very pleasant to let in during showings and stuff like that. But yeah, so you got that one.
So yeah, so thanks, Carrie-Ann, for that. Karen, great question. Anika, I just want to reach out and say thank you so much for jumping on today, taking time out of your busy day. As everyone who's listening, obviously Anika is extremely knowledgeable on this topic. We will have her contact information below. If you do have any questions or are looking for any assistance in this field, certainly a fantastic resource to get to know. So Anika, thanks again, and appreciate your time.
Thank you very much, Anika.
Thank you so much for having me.
Okay. Take care.
You too.